Welcome back. Thank you very much for staying with us. The first witness in the trial within a trial has told the High Court in Pretoria that Muzi Sibiya, accused number one in the Senzo Meyiwa trial, appeared normal when he made a confession to him. Colonel Mhlanganyelwa Mbotho testified that Sibiya confessed on the same day of his arrest on the 30th of May 2020. Mbotho said that Sibiya had no injuries other than those on his wrists due to the handcuffs that were tightly fastened. This contradicts Sibiya and accused number two, Bongani Ntanzi's versions that they were tortured into a confession. Legal analyst and attorney Ulrich Roux joins us for more. Mr. Roux, a warm welcome to you. Thank you so very much for availing yourself to SABC News this evening.
Hi, good evening. Thank you for having me.
You're most welcome. All right, let's start by maybe breaking down, if you can, for us, under which circumstances really we see the need for this trial within a trial.
So in this particular case, the state wants to adduce confessions made by the accused or alleged confessions. And the accused are saying that those confessions were made under duress, and accordingly no evidentiary value should be attached to it. Now, a confession, when it is handed up in a court, is what is referred to what we call real evidence. Now, real evidence is a document, in this instance, a document containing a confession, and the court then needs to adduce and hear evidence and make an adjudication if that real evidence handed up should be accepted by the court as proper evidence or not. If the court is convinced that the confessions were made whilst the accused were not under duress, in other words, they were not forced to make these confessions, they were not assaulted, they were not threatened in order to make them, then the court will accept it. Whereas if evidence is led and the court accepts that evidence that they were threatened in order to make those confessions, then the court will not accept it as real evidence, and the court will not regard those documents as confessions made by the accused.
All right, I want to continue talking about the admissibility of confession that is then in dispute. Are we talking about all aspects and all parts of the confession? Because, I mean, I think in this particular case, there were many aspects. We also heard about, written confessions. We're talking about spoken confessions. We're talking about what was called pointings out, where, the accused are taken to the scene and they point out certain things. Let's say in this situation, one part of the confession is under dispute. Let's say the first day that they were, orally giving, confessing. Might that be written off, but other aspects be taken into account that, you willingly, without being assaulted, accompanied police and you pointed out certain aspects? Can everything then be written off based on that, if it happens that they were, in fact, assaulted on one occasion?
Well, it all depends on the evidence that is led during the trial within a trial pertaining to each specific aspect. So as you correctly point out, they are disputing that the confessions made were done properly. They are saying that they were assaulted and threatened, and accordingly they made those confessions under duress. But they're also saying that the pointing out of the scene and numerous other things that they pointed out were also made under duress. So evidence will have to be led, and the court will have to make an adjudication on each of those instances. It is not a case of, if the court finds the confessions to be admissible, that everything else will then be admissible as well. And the court will have to adjudicate on each instance of this evidence and what evidentiary value must be attached to this evidence, and whether the court can in fact accept it. It is called a trial within a trial because, as I said, specifically with regards to the confessions that were deposed to, and it was a statement that was signed by the accused under oath, that is real evidence. It is handed up to the court. It is not oral evidence led, and the court must make a determination whether it's going to accept that or not. Because the minute that it is handed up, that essentially means that the court accepts it, and the court must take it into consideration. Now, this obviously has a big bearing on this case. If a confession was made by accused number one and accused number two, and those confessions are accepted by the court, then the verdict would most likely not be in the favor of the other accused or of accused number one and two, because they've essentially admitted to having committed the crime.
Well, I can imagine that the defense, wouldn't particularly, like the issue of the confessions and what was said and what was confessed to. Is this, and I mean on a general term, not just specifically this case, but is this some sort of a tactic that, the defense teams use to kind of evade responsibility based on their own client's confession, or is this, a reality that this often does happen where people are coerced by being assaulted into giving confessions? I mean, what's your assessment? And I'm asking generally so that you don't have to put yourself in this particular case. But is this a ploy?
Well, remember that we as lawyers are creatures of instructions, and we take instructions from our clients. So in this instance, if accused number 1 and 2 have made it clear to their legal representatives that they were in fact assaulted and made those confessions under duress, then it is the duty of the attorney to place that before court and to argue that before court. So, it would not be wise, and it could be detrimental to your reputation as an attorney if you just use this as a ploy to try and get your client off the hook, so to speak. There must be proper grounds in order to argue that a trial within a trial must be held in order to determine the admissibility of a document such as this, which is a confession which needs to be handed up. But all evidence during a criminal trial must be tested properly, and the judge or the magistrate presiding over the matter must attach a certain amount of weight to all evidence that is led during a trial or that is adduced or handed up to the judge or the magistrate. And in this instance, the judge has correctly ruled that a trial within a trial must be held, and he must hear evidence as to if these confessions were made under duress, whether that was indeed the fact, and what weight he must accordingly attach to that evidence. So the correct steps are being followed by the court, certainly.
Yeah. Advocate Mnisi, one of the advocates for the accused, said something I found quite interesting. He said that, let me quote him, "We cannot get into a trial within a trial without knowing what the state is alleging against us." And of course, then the judge, as you rightly said, ruled that the trial within a trial should still, you should commence. What do you think the advocate's plan there was? I was a little bit confused because, I would have thought that the trial within the trial was, something that would indeed benefit, the accused. And then it seemed as though, he was questioning, what was they were being, the state was alleging.
Yes, I also found that strange. One must assume that the defense and the accused would have seen these confessions before this trial commenced, because they would have formed part of the docket, and the defense receives a copy of the docket before trial starts. So it's not clear to me as to why he said they need to know what the state is going to allege. I mean, it is the onus rests on the defense in this instance and the accused to convince the court that those confessions were made under duress. So I'm not certain what he meant. Certainly a strange strategy, in my opinion. But once again, if they allege that the confessions were made under duress, then the onus is on them to prove that, and the judge will consider all evidence led and then make a finding firstly on the trial within a trial. So the judge will consider all of the evidence led, then make a finding whether the confessions must be accepted and handed up to the court as real evidence. Whereas if he's convinced that the confessions were in fact made under duress, then he will discard that evidence and he will not take it into his consideration when making an adjudication in the matter.
All right, it's always a pleasure hearing your analysis, Mr. Roux. We certainly do appreciate it here on SABC News. Ulrich Roux, legal analyst and attorney.